Well, good evening to everyone who has tuned in tonight. My name is Joel Crowder, and on behalf of the Law Related Education Committee of the State Bar of Montana, I want to welcome everyone tonight. It is fantastic to see the launch of the Citizens Law School, and it's the culmination of a lot of hard work to organize this. But we have a great lineup of legal topics and legal practitioners that are starting tonight and will be running through the end of November. The mission of the Law Related Education Committee is to provide the public information and education on the importance of the rule of law in a civilized society, the legal rights and responsibilities of the individual, and the workings of the legal system, including the role of attorneys and the judiciary. It is my honor tonight to introduce Hertha Lund, an outstanding Montana attorney who I can actually say I've witnessed her great work in the courtroom in action over the course of my own legal career. In 1992, Hertha was working as a journalist covering Congress, the executive branch, and the Supreme Court. She was assigned to report on one of the most important cases regarding the Fifth Amendment, Lucas v. South Carolina Coastal Commission. Her experience that day catapulted her career into fighting for private property rights. Hertha has been defending landowners' rights for more than 30 years at the national, state, and local levels. She has trial experience and has prevailed in high-value cases involving property rights. Hertha has appeared before the Montana Supreme Court, the Federal District Court of Montana, the Ninth Circuit Court of Appeals, the United States Court of Federal Claims, and the United States Supreme Court. In 1995, she clerked for Chief Judge Lauren A. Smith of the United States Court of Federal Claims. Hertha is the founder and owner of Lund Law and is a Montana member of the Owners Council of America. She practices in the areas of property rights litigation, eminent domain, water rights, and other general litigation. Over the course of her career, she has worked for the American Farm Bureau Federation in Washington, D.C., the Montana Farm Bureau Federation, and the Washington Farm Bureau Federation, where she worked on complex water issues related to endangered species, salmon, the tribes, the states, many federal agencies, and agriculture. Hertha grew up on several large cattle ranches in Montana. She started rodeoing at the age of 9 and was a state champion in several events. During high school, she was in the top 10 in the nation for breakaway roping. In college, she played 2 varsity sports, basketball and rodeo, for Montana State University. To pay for her college education, she ran her own horseshoeing, blacksmith business, and worked as a waitress, bartender, and janitor. Her family lost their family ranch during Hertha's college years. Currently, Hertha lives on a cattle ranch with her husband, several cow dogs, many cows, and a few horses near Lennep, Montana. She also recently launched a new endeavor called 4 Horses for Wholeness, in which she partners with her horses serving people with the equine Gestalt coaching method. She recently finished a first draft of a memoir sharing her profound healing after a near-death experience in 2015. Even though she has 2 professional businesses and helps her husband and some on the ranch, Hertha still finds time to ride her horses and enjoy the bounty of wildlife and nature surrounding their home. She has published numerous white papers, law review journals, chapters in books, and articles in national publications on the issues of property and water law issues. So tonight, I'd like to welcome Hertha Lund, and we look forward to hearing what you have to share with us tonight. Hertha?
Wow, thank you so much, Joel. That was a very nice introduction. I'm going to go ahead and start sharing my screen, and we'll talk from that. So I have to go back one, it looks like. So tonight we're going to talk about Montana ag law and water law. And that's a really broad category. So I have pretty much narrowed it to the areas where we have an intersection between urban and rural areas. And there's no place right now in Montana where we see more cases coming than easements. So we'll talk at the beginning a little bit about easements. We'll talk a little bit about nuisance law. That's another place where there's an intersection between urban and rural landscapes, which we obviously have a lot going on around Bozeman and other areas in Montana with high growth. And at the end, we'll talk a little bit about water law. And I will stop and give about 10 minutes at the end for questions. So hopefully that will work. And you can also put your questions in the chat if you know how to do that. My associate Ben is here and he'll help keep track of that. And I may be able to answer questions even as I'm going along, so let's try to see if we can make it a little bit interactive, even on Zoom. So easement law in Montana. And if you think about what's important when you have, agriculture, obviously you need land, you need property. And what is property? We all know what real property is. It's the land. And in this picture, you can see where the horses are standing. That's the land, and we know that's real property, and you can define it by meets and bounds or a legal description. And, so that's the first thing we think of when we think of property. But another property interest is an easement. At the Supreme Court, they talk about this bundle of sticks in your property rights. So if you own real property, you have the right to exclude others. You have the right to fence in your animals. You have the right to use it for your purposes. To you could give a road easement. You could say no to a road easement. You could give an easement for a pipeline. So an easement is one of the sticks in the bundle of sticks is real property. So easement law in Montana, you can get them several different ways. An easement can be created by an instrument in writing. An instrument in writing means something that would give, it's a granting of it. A deed is an instrument in writing. And you can also write up a written instrument that's a grant of an easement. An easement can also be created by operation of law or by prescription. So I talked about express easements by a grant and a written instrument already. An implied easement, that's where it's created by the operation of law. At the time of the severance, so let's say you have a parcel that's 20 acres, well, let's say it's 40, and you divide it into two 20-acre plots. I went to 20, so that we hopefully didn't have to, we got to worry about subdivision. We don't want to worry about that tonight. So you split the property up into two different properties, and that would mean that if you two parcels are in common ownership, then there would be could be an implied easement. And then there's also easements by necessity. You have to be able to provide access to landlocked parcels, and easements by pre-existing use. Now, just because we argue that these are there, it doesn't mean that, what you basically get is you have the right to go to court to say that you have an implied easement. If John says he has an easement and his next door neighbor says, Jake says, no, you don't, we use the system of law and go to court to have the court interpret, whether or not there's an implied easement. The last way is a prescriptive easement. The law's prescription is that if property is used a certain way over a certain amount of time, you can get a prescriptive easement through adverse possession. So let's say you have a ranch over by Miles City, and your next door neighbor has been driving across your property for a few years. If you don't want them to get a prescriptive easement, you have to tell them that, you either have to give them permission, because they have to do it against, without your permission to be able to get a prescriptive easement, or you have to stop them from using it unless you want them to get an easement. And I'm going to go ahead and let Ben talk right now about some of the easement examples. And these are, we're not going to tell you where they are, but these are some case examples. We have a lot of easement cases in litigation right now because of the growth and all the people moving in and people wanting more roads for their developments. So go ahead, Ben, tell them a couple examples.
Yeah, hi. So I'm Ben Storms. I'm an associate with Hertha at Lund Law. So we do have a lot of cases now that what Hertha was describing, where there's, kind of rural environments that are closer to a city, say Bozeman or Missoula, for an example. And what kind of happened was back in the 80s and 90s, kind of commonly, is that big developers own large chunks of land and they divide them up into 20-acre parcels, let's say, for the most part, kind of big, but still rural, but kind of divide them up. And, people moved out there, they built some hunting cabins, or they just invested in the land. But, over the last few years with COVID and people moving out here, Montana getting more popular, there's been a lot more development of people out of state, or people in Montana as well, wanting to build houses and do construction out there. And there's been a lot of problems because the developers didn't build road systems. So Hertha just described to you that you can have an express easement. So a lot of these cases have an express easement, but so every lot's guaranteed access, but no one built the roads. So you have a bunch of fights over who gets the right to build the roads. Is a 2-track that people just started using, is that part of the easement roads? And so a lot of the cases we're seeing are about interpreting legal documents, and also some prescriptive easements through customary use, Hertha described, and seeing who has the right to access, who has the right to build the roads, which roads in easement, who gets to choose where the road goes. And these are all examples where these cases where you buy a property and you see that you have access ends up being a big deal. And it's not really clear who has the power of access and to choose the road. So this kind of intersection of more rural properties that are kind of getting grown out from the cities, and you're starting to see, in the past it wasn't busy enough to have fights over roads and construction, and now they're really growing. So those are some examples where easements can actually become pretty crucial in whether or not how you use your property to get to your property, or as a person who owns property already, to not have people traversing across your property if you want a secluded cabin retreat. So those are some of the easement conflicts we can kind of see in a rural and urban kind of merging together.
So suffice it to say that if you are buying property, be extra careful about your access. And I would probably want to have an attorney do due diligence on that issue, as well as water rights, so that I actually knew what I was getting, because we have people come to us after they purchased something and it didn't turn out being what they thought they bought. So the next issue is nuisance law in Montana. Now, what is nuisance? Nuisance is a way that when you own property, if somebody, the common law nuisance, it's most normal when we learn it in law school, is somebody burning tires, and that smoke comes over your ground, so it's a nuisance when that smoke goes from the neighbor's ground to your ground. But it could be multiple other things. It could be the odor of a sewer. There are multiple things that if it's something that comes across from the neighbors onto yours, it can be a nuisance. And so let's talk about, animals could be, that could be a nuisance. And in this one is our horses beauty or nuisance? And obviously I think they're beauty, but somebody might think they're a nuisance. So that's the question. So the question is, could a nearby landowner bring a lawsuit seeking to close a horse facility or curtail its operations simply due to the smell of manure? Now, obviously, I don't think that smells bad, but some people might. And yes, somebody, now, first of all, if anybody ever asks you, can anybody bring a lawsuit? That answer is probably always yes. There's a question of whether it's likely to prevail. And in this case, they could bring one. And, the question will be, did the neighboring horse facility improperly interfere with the use and enjoyment of the neighbor's property? So here's a definition of nuisance: is a unreasonable, unwarranted, or unlawful use by a person of his or her property that produces a material annoyance, inconvenience, or discomfort to another nearby landowner or the public. And there is a defense. So if the complaining landowner actually bought their land and moved to the place after the horse ranch was there, then he came to the problem. So that would be a defense to being able to claim a nuisance. So if you buy next to a pig farm, you probably will have a hard time suing because there's a pig farm there. There's also natural right to farm laws, and what those are, they're all around the country, and we actually have one in Montana. So these laws create a rebuttable presumption, which that means is that there's an assumption that the agricultural operation is not a nuisance so long as it is complied with accepted farming practices and environmental regulations. So I won't read all of the rest of that because we have lots to get through. Montana's nuisance law says that if the establishment has been in operation longer than the complaining resident has been in possession, then there would not be a nuisance. So that's some of the ideas about nuisance. And we do have people come to us and want to try to change. So the bottom line is that if you buy into a place and there's a commercial use there, you'll have a hard time going against it. So if it comes in after you, your nuisance case will be stronger. Now we're going to talk a lot about water law in Montana. This is a big issue. I actually just got back from going back east and talking at William and Mary. Water in the West has become an issue that's important to many people across the country because of the scarcity. And we actually have a very good system of water law in Montana, and the fact that we've taken care of it and our legal system is robust, and I think one of the best in the West, literally. So there's a real question of who owns the surface water in Montana. Most of the eastern states have a riparian doctrine, which means whoever along that stream, if we were in the east, we were looking down the stream, whoever has land next to the stream can take water out. In Montana and the other western states, we've developed what's called the prior appropriation doctrine. And what we have is if you have to put it to beneficial use, and you filed on your rights historically what you used, and it's a right to use a certain amount of water at a certain place for a certain specific use, like irrigation, stock water, power generation, your house, your well for your house, domestic for city water. So it's a certain right, for a certain amount of time, and to be able to get a water right, you had to file on it, and you have a right to divert it out of the stream and take it to your place of use. And the water rights for prior appropriation doctrine are usufructuary. And what does that mean? It means that it's a right of using and enjoying and receiving the profits of property that belongs to another. So it's a right to take water from the watercourse, our groundwater basin, both of which belong to another. Who's this another? So who does the water belong to? In Montana and other Western states, all the water belongs to the people, and it's subject to the appropriation of beneficial use. That's in our Constitution. So if you have a water right in Montana, you don't own the molecules of the water, but you do have a real property interest in the use of that water. So the owner of a water right they have the right to use the exclusive use to use that water at that point of diversion for that use. And the prior appropriation doctrine is first in time, first in right. So the oldest right, the person who put it to the use first, if there's a time where we don't have enough water to go around, the oldest right wins. So you just kind of go up like the ladder. If you didn't start using your water until last year, you'd actually have a permit, because you can only get permits after 1973. Yeah. And so, but if you have a prior appropriation vested water right before then you say you had a 1969 interest. Well, there's some water rights in Montana that are 1880 something. We have water rights that predate statehood. And so the oldest water right wins in the scarcity. So the next question is how do we regulate the use of water in Montana? And as I told you before, prior to 73, a person could acquire a water right by simply putting it to beneficial use. And the prior appropriation doctrine in Montana's water rights system kind of took after mining claims. If you wanted a mining claim, you would start using it and you would stake your claim. And that's what we did with water in the beginning. And our legislature recognized the needs for the amounts, ownership, and priority dates of water rights to be more clearly defined. So they passed the Montana Water Use Act in 1973, and that established an adjudication system, or the water court, to be able to determine what are the interests. Now it's like, why would they have to do that? Well, think about it. People had to file on their water rights, and then they had to refile in the 80s to see, update the filings to make sure that we had this right. It's very simple if you're trying to decide what a real property interest is, because you can see it and you can do a legal description of it. And a water right is literally amorphous. And to be able to decide what the property right is, you have to figure out how many acres it's used on, where it's diverted, what use it's for, when it was put to beneficial use, that the priority date's right. And so the court system has been on this long time engagement on making sure that all the water rights are accurate and that there's no that's wet water. By a lot of the water rights were overclaimed, so it kind of trims out what's overdone and breaks it down to what's actually been put to beneficial use. The other thing about our Montana prior appropriation doctrine is that if you don't use the water, you will lose it. And that's, the system doesn't like waste. So we'll talk about that a little bit more. So the Montana Water Use Act, as we talked before, it's first in time, first in right, and use it or lose it. Here we have, on this slide, we have stock water drinking out of an irrigation canal. So there's two water uses going on there. And the prior appropriation doctrine is, the first, you put your water rights acquired by taking possession of the water on the public domain and putting it to a beneficial use. And the priority date is the date that the water was first put to beneficial use, or the date the notice of appropriation was filed, if you don't know when it was first put to use. So in the prior appropriation doctrine, so Ben is sitting here, if we are now neighboring ranches and he has a senior right to me and I'm still using my water, I'm the junior right, he can do what's make a call. And that literally means he gets a hold of me, talks to me at the mailbox, or calls me and says, hey, Hertha, I have a senior water right, I'm placing a call on your water right. And when he does the call, I'm supposed to stop using my water so that he can get his use. If I don't stop it, he can take me to court. And right now he would take me to district court. I don't know if people know it, but the first murder they say in Montana was over water rights. And like they say that Mark Twain said that whiskey's for drinking and water's for fighting. So in this system, instead of fighting, we have a law that says if you want to use your senior water right, you make a call, and if you can't use it, you go to court. And hopefully that keeps this the disagreements over who has what civil. And then this is really getting detailed, but I could tell Ben that I'm not going to give you your water because it would be futile. And by that I would say, no matter if I leave all the water in the stream, it won't get to you. And he could say, well, I think it might. And then we would argue in court over whether or not I was right, that it was futile. There wasn't enough water to get to him. Again, the doctrine for Western water is not to waste it. It's to be put to beneficial use or left in the stream. So this is an illustration of, that if you notice those people, the first one has an 1892 water right. He's first in line. The next one's a 1923, 1963, and 1972. After 1972, you would not be able to have a vested right. You would be able to get a permit. And we'll talk about that a little bit more. You still have a right to use water. It's just one's a property interest and one's a permit. Now, abandonment and water rights, if you live anywhere in rural Montana where you have water rights that aren't any water rights technically, but it'd be harder to lose the ones for your house, because technically if you live in a house, you're using your water. But if you have a right to irrigation or something, you really want to put it to beneficial use at least every 10 years. In the future, once adjudication is done, you have to put it to use every 5 years. So it will change, and right now it's 10 years. If the water is available to use, you have to use it, or you lose it. So if somebody goes to file that somebody's abandoned it, you have to prove both non-use and the intent to abandon. So I could not have used my water for 12 years, but if I still have my ditches and everything there, and I just didn't use it because there was a drought and there was no irrigation water, then it's highly likely I would have a good case to prevail against abandonment claim. So these are some statements from some of the cases. 9 years of non-use represents very potent evidence of intent to abandon. And then if a continuous period of non-use is established, they have what's called the burden of proof shifts to the water rights holder to provide specific evidence rebutting that presumption. So this is if you're going to court, what that means is that once the other side proves that there's continuous period of non-use, then instead of me not, now the burden shifts to me to where I would have to prove, that why I didn't use it and that I had intent to use it, which is usually evidence that I have ditches and they're all working and stuff. And lastly, mere expressions of hope or desire regarding future use will be insufficient to overcome the presumption. That's another way of saying that if I'm living on my place and I hope to be able to grow hay in 10 years, that won't be enough to overcome, somebody claiming that I abandoned it if it goes too many years with non-use. So bottom line, if you have irrigation rights and you're not sure about whether or not how long they've been used, and note, the clock doesn't start when you buy the place. The clock starts with whoever used it last. So it could be 3 different owners, and if there's 10 years of non-use, the 4th owner gets it, you could lose your water rights. So this is what I told you before. Pre-73 are water rights, and I call those vested water rights, are property interests. Post-73 are permits, according to the Montana Water Use Act. I know I'm giving you guys a lot of technical stuff, but there's a lot going on with water rights, and these are the cases where when people are buying property and they don't get legal advice, we see a lot of these issues coming in with people and people wondering what they actually have. So if you have a post-1973 water right, you have a permit from DNRC, you can change those water rights, but you have to go through a process that the Montana Department of Natural Resource Conservation process that they have. In Montana, all water uses are equal: stock, irrigation, domestic, municipal, commercial, etc. Other states have established a hierarchy of use, which means that some of those uses trump other ones, which kind of takes away from the property interest. But in Montana, they're all equal. We also have in-stream flow rights. When we first started our property rights system, you had to take the water out of the stream to put it to beneficial use. The legislature changed that and made it so that you could have in-stream flow rights for fish, so that you could protect stretches of streams for fish. Okay, yeah, what's the water law question?
I'll read it out loud.
Okay.
If Montana water, so there's a question from an attendee on a water law, and I'll ask it here. We get other questions later as well, but if Montana water law statutes control, how is the state of Montana and the U.S. government allowed to enter into compacts with Native American tribes to change, limit, or affect the landowner's water rights? And the attendee gives the example of the Flathead Valley of Native and state water rights.
Yeah, that's a very good question. And if the law, the way the courts have been interpreted is that anytime a reservation was set aside, they had an agreement with the federal government, a treaty. And in those treaties, the federal government, back before that we were a state, in some cases, gave the tribes a certain amount of water for the reason the reservation was set aside. And some tribes got treaty water rights for fishing. There's only one tribe in Montana that got those, and that's the Salish Kootenai, Confederated Tribe of Salish Kootenai. And with those water rights for fish, they gave them water rights that were off reservation. And the courts have found this over and over again. It is solid and true law. And this is a really important time to kind of point out that when I try cases, I oftentimes don't agree with what courts say. But in America, we have a system of laws and we have courts interpreting them. And when the courts interpret them, the future courts just have to follow those. So we can say we don't like it, but it is the status of the law. And in this case, the courts have found all the way to the Supreme Court, and there's actually Neil Gorsuch has recently heard other treaty tribal cases and has been a staunch defender in the heels of Scalia, who is an originalist interpreting contracts and upholding the tribes' tribal interest in their treaties. And so based on that, Montana is one of the only states, and we're way ahead. Thank goodness for the legislature when they set up our adjudication and our compact commission. I just spent time, as I told you, at William and Mary talking about water rights, and California has not adjudicated their water rights. And so now they have a drought, and they're gonna have a really hard time protecting their property interests because they haven't adjudicated. They don't know who has what right through a legal system of figuring it out. They have not done their compacts with the tribes and the federal government. The United States Forest Service, the BLM, they also got water rights in the Park Service for whenever the land was set aside for the purposes that the federal government did for those lands. So they also got their own water rights for that. In Montana, we had a compact commission that figured out how to quantify those, and all of those compacts are now done, and we are so much farther ahead than the other Western states. We're I think one of the best systems in the country to be able to protect all users' water rights under a property rights system because of what we did looking ahead for adjudication and for doing the compacts and making sure that we could quantify uses. So back to the existing water rights, I think we talked a lot about all of these already. So, when the water court has been hearing all of these cases to literally quantify and have a judge decide what are the valid claims of individuals, of the tribes, and the federal government, so that in this system, we know who has what. And that's been going on for several decades. And I think we're hopefully, within the next potentially 5 years or so to be able to get done with that. And again, there's only one state that I know of that's better than us, and that's Colorado as far as being fully adjudicated. So statement of claim is kind of the same thing as a deed for your water right. And people file those, prior to 1982. And then those statement of claims is what we prove up in the water court through adjudication. And if you missed that deadline in 1982, you actually lost your water right. Some rights were exempt, and that was stock water and domestic rights. And they did have a deadline to file your livestock direct from source, like from a stream. You had to file those by 2019, but you didn't have to file them in 1982. Domestic rights are still exempt. So those, if you have a well. This is what a statement of claim looks like for irrigation water right. You'll see on it, it says the owner, it says how it gets from the main source, a ditch, whether in this one is a stream. This is in Fergus County. It says it's a head gate. So these are all the attributes of your property interest in a Western water right. Here's an important slide for anybody who's possibly looking to figure out how to figure out what they have. You can go onto the website, wrqs.dnrc.mt.gov, and you can look up your water rights there. And a general abstract is a current version of your water right. That's what the water court issues. And again, this is kind of like the equivalent in water law language to a deed for real property or land, not real property, because they're both real property. Now, you could, I'm going to talk about that when we go to the next slide. So this is a general abstract that this is what the water court issues. Now, you could, I told you could go to the DNRC to change a water right. And it's a very expensive process. You could change a place of use, a place of storage, a point of diversion, but you have to prove that you will not adversely affect other water rights. This process is expensive, time consuming, and not guaranteed. I've done some of these change applications, and all of them have cost in the tens, 20s, thousands of dollars, up to 100,000, and you have to hire a hydrologist. So you have a hydrologist and an attorney, and there's right now the status of the law is you have to prove no adverse effect, which is a de minimis. It's almost like trying to prove a negative. So it's very hard, and very few people have been able to actually change a water right under the current status of the law. I know they're trying to fix that in the next legislature, so hopefully they'll get that done. So these are all the things you have to prove if you want to change your water right. You'll have to prove that it will not adversely affect the neighbors that I already told you about. The proposed means of diversion, construction, and operation of the appropriation works are adequate. You'll have to prove that it's a beneficial use, and the applicant owns or has permission from the person who owns the property where the water is to be used. And they can also object on water quality. So again, this is very hard to do changes under the Water Use Act.
I got a question.
Okay.
So there's a question on change apps. Someone's asking if, do you have to go through this permit process when you're just changing the water rights and families like being handed down through inheritance?
No, if you're handing it down, you're selling the real property and the water rights are pertinent and they're going with it. You do not have to go through the change process, but you do have to file documents and get the title to the water rights changed at the time of the sale. They're usually pretty good now when you're selling property to have you fill out a form to make sure that the water rights are transferred at the same time. It used to not happen, so that the records were kind of a mess. But currently, it seems to me that when they're doing closings, that they make sure that you sign the paperwork to transfer the water rights. One thing also is that when the DNRC issues a preliminary decision, if they're going to grant a change, then they also put it out for public notice so that other water users may file an objection. If there is an objection, then there's an administrative hearing. And then if whoever hears the hearing, that can be appealed to district court. So you can see that it costs a lot to get the application done. And if you get it through, then it can be objected to, you have a hearing, and then that can be appealed to the district court, and then that could be appealed to the Supreme Court. So it could take a lot of time and a lot of money to get an application, of change through, and then you could still lose at the end. There's no promises. This is what the application looks like at the beginning. Guarantee you the file gets very big from here because of what your expert has to find, and the DNRC's expert looks at it, and it's a big process. Now you can amend a water right, and this goes to the water court. But there are many places, since adjudication is getting close to being done, if your water right has been adjudicated, you can't do amendments on those. So there's very few areas that haven't been adjudicated, and those are still places where you might be able to do an amendment. And that would be if there was a clerical error, like the time of use was wrong or something like that. But if you wanted to file an amendment, you would file it with the water court, and you can do amendments on the elements of the priority date, flow rate, volume, place of use. Now you can't just do this, because you want to. There has to be some error, and it has to be based on historic use. So it'd be some type of mistake that occurred in the filing that didn't track historic use. Now we'll talk briefly before we're done about new water rights. And these are the permits that are anything after 1973. So if you're a water user looking to acquire a new water right, says our law says you can do that by going to the Department of Natural Resources and Conservation. And you have to obtain a permit before you construct the diversion works or divert water. There's limited exceptions for small groundwater wells that's less than 35 gallons per minute, or small stock ponds on non-perennial streams. So those are exceptions to being able to have to get a permit before you start. So the first thing you got to look for is closures. You can't have new appropriations in closed basins. What's a closed basin? These are places where the legislature has decided that these basins are already over appropriated. that means there's no water left to be handed out in permits or to be used. And right now in the Bitterroot Basin, Jefferson and Madison Basin, Teton Basin, Upper Clark and Upper Missouri, these are closed basins. Here's a map you can see on this area. The green is, we also have administrative closures. So we have, the purple is Montana Supreme Court order closure. You have DNRC ordered Milk River closure. And then you have the other basins that are closed. So there's quite a bit of Montana in the populated areas where you wouldn't be able to get a new permit because they're controlled areas and it's closed. I guess let's go back for a second. If we were gonna be over Joel, I think over here somewhere, about in here maybe, I might be a little bit off. Eastern Montana, you could possibly get some new water, but a lot in the western area, it's populated. These are closed basins. So just be aware of that. So the first thing you'd want to do if you're going to get a permit from the DNRC is check for closures. And then you're going to check for exceptions that we talked about. And oh, I didn't mean to do that. So you have to be located on a parcel of land that's 40 acres or larger if you're going to use it for stock water. And you have to fill out the correct forms before you start, unless you're an exception. So 1, check for closures. 2, check for exceptions. 3, apply for the permit. Expensive, time consuming, and not guaranteed. So what they're going to look at if you try to get a permit, they're going to see if the water is physically available. They're going to look at the legal demand. So they're going to look at all the other places the people who have water rights on the source to see if there's enough left for you to be able to have yours. And they're going to look at the effects of the proposed use on the existing water rights. They're going to do an analysis on that. And they're going to look at your design and operation of the proposed system, a description of the beneficial use. They're going to look at how much flow rate and volume you're requesting. That's how much water you're going to pull out of the stream and put on whatever your use is. And that you actually have a possessory interest in the place of use, or that basically that you own the land or you lease it, you have a right to use it. Now, this is your flow chart for getting a permit. We won't go through all of it, but suffice it to say, when I look at that, I see, oh my Lord, how am I going to get through that? Now, we do have some people who have made it through, but I'm not kidding you. This is one thing that I know that the governor is trying to figure out a way to help this go faster, but we all want it to go fast, but we still have to take care of current rights also. So it is a very hard problem to solve. So now I actually got through the whole thing, and I know that was a lot, but I think we're right on time. Yeah, so I can answer any questions, and so I kind of like this graphic. I was water before it got so cool.
So we have some questions from the previous topics, and the first one's about prescriptive easements. What is the statute as the time period for prescriptive easement? 5, 10, or 20 years?
Yes, I'm gonna have Ben answer that.
In Montana, it's 5 years for a prescriptive easement. It's not just 5 years, you use it once or twice in 5 years. It has to be, like Hertha said, open and notorious, meaning that you're openly using it. It was hostile, meaning permission, and that it was continuous. So it has to be a pretty repeated use. Like you were walking and a trail starts to form, you start using it a decent amount. So yeah, it's 5 years Montana. Some states are 10 or 20. It all depends on how long of time you want it to happen, but in Montana it is 5 years. The other question that was from the earlier in the presentation is on nuisance, and I think particularly right to farm laws. Can you elaborate on a right to farm if the farm operation is newer, but following all proper laws and practices?
You have an answer?
Yeah,
Go ahead.
as well. So, Hertha described to you how in a nuisance case, sometimes it can be a defense for you to say, well, I'm operating this farm and, the person moved here after I've been farming for all these years, so it's not a nuisance. So this question is going for the opposite scenario. What if I start farming, I move somewhere, make a farm, and everyone around me, did not live there when a farm existed, and I made the farm. So what right to farm laws do is protect the right to farm, obviously. So it would bar a nuisance claim. Many of the statutes make a scope what kind of farming you can do. So, if it was really egregious and outside the scope of the statute, you could probably still maybe bring a nuisance claim. But what the right to farm laws try to accomplish is that we were talking about the kind of this talk, the intersection of agriculture in rural and urban, is that allowing people to still use their land for farming without being challenged on nuisance. So right to farm laws try to shield new farms from being developed from lawsuits.
So we're still open for any more questions. So you can either send them in on the chat, or you could also unmute yourself, I think, right now.
You have another question?
Okay, another question.
If your water rights are subjected to the Kootenai Compact, are your water rights extinguished or irrelevant?
No, there's nothing in the Salish Kootenai Compact that has extinguished anybody's rights. All it did was quantify what the tribal rights were that they got with the treaty. And it also, the compact actually, they had, Salish Kootenai had claims all across Montana to Billings and almost the whole western part of the state. The compact actually extinguished those water rights. They gave them up for the compact and what they got with it. So no, the compact doesn't extinguish anybody's water rights. And it also made it a system for, if somebody's non-Indian on the reservation, they still have those rights also. So there, it did not extinguish anybody's water rights. I know there's a lot of talk about it, but that's not what happened. So we do have like 10 more minutes. So what else could we tell them about? I would let you know about some cases that we had, with people buying property. And one case was they thought they got senior water rights, and they went and spent money on fixing the head gate, and then the next door neighbor shut off so they couldn't use the ditch. And so now we're litigating about whether or not they had valid water rights and whether or not they have a ditch easement. And in that case, the realtor, the seller made certain representations, and the realtor thought that was a case where it would have been really good to do what we call due diligence, hire an attorney to look at the water rights and tell you what you have so that you're aware of any risk. We have cases going on about, why don't you explain? Okay, we have a new question.
Yeah, you have two new questions. So we're still talking about water. So once all the water rights are fully adjudicated, will there still be a possibility for getting new permits, or will all the permits that will ever exist already be established?
No, you will be able to get new permits, but you have to be in an area that's not a closed basin. And let's say that you got a permit tomorrow, it would have a priority date of 2022, which means that every water right that was ahead of that would if there was a shortage, they would all be ahead of you. But you, in areas where it's not a closed basin, you can, if you can jump through all the hoops of the statute, you can still get new permits. But in the future, a lot of water and a lot of the cities now are trying to buy water rights to be able to convert to municipal use, because there's just not a lot of water in certain places available. And so you have to try to buy somebody else's senior water rights or buy their property and transfer their water to a new use.
So we got another question about abandonment. So if someone has a water right for irrigation, but it has not been used in the last 10 years due to water not being available, I would imagine, maybe a drought, would that be considered abandoned?
Well, I want to be really careful here. Abandonment is a case, it's a case-by-case analysis, and it's facts. The court would look at all the facts. But if it's not available, that is one of the reasons that it would be that you didn't abandon it. If it's not available, the time doesn't count against you, but you have to prove that it wasn't available and that you intended to use it. So that would be whoever was trying to protect their water right would have to prove that.
Another question of how do you find where's the source of that closed basin map that you showed everybody? Is there a way to find that map?
I'd have to go back and look at it. I think the DNRC, if you typed into Department of Natural Resources, their website, and typed in closed basins, that should be able to pull it up for you. And that's pretty important to know. I mean, people ask me questions and I always say, are you in a closed basin? I mean, that's one of the first things I want to know. So.
Oh, here's a question. What is a closed basin?
A closed basin is, they call you can't do county lines for water rights because water flows in rivers and river systems, and they call those the river systems basins. So it's an area that drains, or that water flows, like my husband and I ranch near Lenup, and we're at the headwaters of the Musselshell. So we're in that's the basin. The water from ours place will go into the Musselshell, into the Missouri, and out to the Gulf. So that's the long basin. But in Montana, we have basins, and there's certain areas that have closed these basins because there's more use on them. They say they're over appropriated, which means people have more water rights to take out water, and there's not enough water left to be able to make sure there's some left in the stream, to be able to keep everything working, and for navigation and for fish and stuff. So, so that's what a basin is.
So you got one last, I think we have time for one more.
One more question.
I mean, there's two on here, but we'll go with one first. So if someone bought a house and the seller did not include the water rights, can the new owner buy them after a short time, for example, 5 to 10 years?
Wow, I'm not even sure how, if you have a house and if you have a well, how the water rights don't go with it. But
They're presumed.
And yeah, they're pertinent. So that would be very hard to split them. Let's say it did happen. You could possibly buy them, but you also possibly could put in a well because of the exemption for less than a 35 gallon per minute well, which is still available. So what was the last question?
So we got the last question. Who is responsible for maintaining an easement, such as grading and plowing the easement?
Your property right is different than who has the agreement to use it. So let's say you and your neighbor decide that you're going to share a road easement. You would also want to have an account in addition to your agreement on reciprocal easements, like maybe he has an easement to go across you and you have an easement to go across him, or whatever it is. But you also want maintenance and who's going to keep it up, and you have to have an agreement for that, a road use agreement.
Water rights be allocated if there isn't enough water in the particular basin for all existing rights?
At this point, I think everybody's watching. It's going to be hard to over appropriate, but let's say that in the future we have less water than we have now. The prior appropriation doctrine takes care of that, because whoever has the oldest rights gets to use it. So even if you're over appropriated, you're still limited on how much people can use. Like in where we ranch and in places where they have enforcement in the summertime, we even had enforcement as early as I think April or very early last year. And what that means is that you have a ditch rider, and the ditch rider says only those who are after 1927 can use their water rights. Everybody else, anybody before that can use it, and anybody after that can't take water out. So in the future, and the more people we have, and the more scarcity there is, the more we'll have enforcement, and it will be allocated according to the prior appropriation doctrine, which is priority date. So those who have the oldest rights will be able to use them, and the people who have the newest ones will not be able to use it. Okay, so I wanted to thank everybody for being here for this first citizens law, sharing of the law. And I really appreciate your engagement and your questions and the opportunity to talk to you tonight. And I think this is so important for our future and our ability to, work together and understand the law so that we can take care of our property interests. And again, I thank you so much for your kind attention. And I think that I have, I'll turn it over to you.
Hertha, thank you so much. Thank you to your associate, Ben, is it Ben as well?
Is Ben Storm.
For helping out. I'm John Mudd. I'm the Executive Director of the State Bar. We want to thank all of you for being here today and hope that you'll join us for this weekly series running into November, our opportunity to share the expertise of our members with you and help you better understand our legal system and some of the important areas of law from experts like Hertha. So we appreciate you being here, both on Facebook Live and on Zoom. Information about next week's session and a chance to register for that will be available on the website, and we look forward to seeing you then. Thanks again, Ben, and thanks you very much, Hertha, for being here tonight.
Thank you.
You're welcome. Thank you.